Yes, Your Honor. After these issues were brought to our attention by Mr. Cortez, we did pursue trying to figure out who signed each of these documents, what the process was when they were signed. We weren't able to confirm that the affiants were actually sworn, because I do think we had the same issue Mr. Cortez had on one of the cases, is we couldn't figure out who the affiant was. So we went ahead and tendered dismissals to the court with the intent to refile in the proper manner. And those dismissals were signed by the court.
All right, so right now, these two cases are dismissed.
Yes, Your Honor.
And what was the original date alleged as far as the offense allegedly having occurred, the event date?
Give me one moment to look that up, Judge.
It's a UCW judge and a DWI.
Right. Well, I say UCW, when did that supposedly happen? Or when is it alleged to have happened?
November 12th, 2020.
Okay.
On both cases.
And both of them, obviously,
Yes.
the case numbers are so close, it would have been likely that, all right. Okay. Then as of right now, these cases are dismissed. Mr. Cortez, that takes care of your issue for today. And if the state refiles, of course, they can do so if they choose. I'm sure I'll be seeing you some more on pretrial motions.
Yes, sir, Judge. Thank you very much. Have a good evening,
You're welcome.
Your Honor.
You too. And if I don't see you, have a good holiday.
Thank you, Judge.
One thing, Mr. Cortez,
Yes, sir.
on Thursday,
Yes, sir.
don't gobble.
Yes, sir.
Is
Yes,
that
sir.
considered good form? All
Thank
right,
you, Judge. Thank you,
take
sir.
care.
Yes,
Be
sir.
safe. All right, who do we have now? Ms. Blake? Angela Blake?
I'm here. Mr. Ruiz is here too.
Okay.
Hello, I'm here.
The court calls case number 624634, State versus Teresa Ruiz. Are we ready to proceed?
Yes, Judge.
State
State is, Your Honor.
and defense, y'all have an agreed plea agreement?
Yes, Judge.
Okay. Teresa Ruiz,
Yes, Judge.
please raise your right hand. You solemnly swear that the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, ma'am. You may put your hand down if you haven't already. Ms. Ruiz, before we proceed, I'm gonna do what I call a requirement to inform you of particular rights and protections that are afforded you. One, you have the right to remain silent, meaning you don't have to make a statement, you don't have to answer questions, you don't have to submit written paperwork that has your signature, especially papers that admit or confess to wrongdoing. That's the right to remain silent. You have the right to a jury trial. That is, you and your attorney could participate in a process where you and the state select 6 people from a pool of disinterested U.S. citizens who would hear all the evidence, see the witnesses, and whatever materials are submitted. And that jury of 6 would decide whether you're not guilty or whether you've been proven guilty beyond reasonable doubt. That's the right to a jury trial. You have the right to appeal. Once this whole case is over, the dust is settled, you would have the right alone, or your attorney alone, or the two of you together. You have the right to demand that a higher court review the official record, which is being prepared by a court reporter, Ms. Jaylene Rivera. You'd have the right to have a higher court review that and answer whatever legal challenges you wanted to make. On the appeal, you'd have to be careful because it has time limitations, and you have forms that require, first of all, they have to be certain forms and certain information is required. You have the right to confront witnesses. That means that if you decided to go to trial, the state would have to submit witnesses to try and prove their case. Those witnesses would be subject to you and your attorney asking questions that would cross-examine, question, or challenge any witness. That's called the right of confrontation. And then finally, you have the right to demand that this proceeding be held in the open public courtroom. Because of the COVID pandemic, we haven't been doing that. But in order to proceed with this plea agreement, you were required, or you'd have to review a document titled Defendant Consent to Video Conference, which is what we're doing. We're doing this by video conference over our computers. Now, those rights that I've explained to you are mentioned to you. You understand you have those different rights?
I do, sir.
All right. Now, in order to proceed, you have reviewed and signed several other documents. You've already acknowledged that, do you acknowledge that you have reviewed and signed the consent to video conference?
Yes, sir, I have. Yes, Judge.
You also had a very important or critical document called that all of these identify you at the top. And then there's one called named Defendant's Waiver of Constitutional Rights at Court's Admonitions. Now, what I just told you or talked to you about constitutional rights and admonitions. In this case, the document that I'm referring to tells you about these things in writing. And there's part of the documentation that has 14 separate paragraphs or declarations that talk about different important items, everything including that whatever deal you've made with the state is not binding on me. And it informs you that I have the right and the obligation, the authority and obligation to say yes or no to your deal. I have to say one way or the other. I also have the right to punish you in accordance with the offense that you plead to. And I can give you a punishment that might be greater than what you agreed to, but within the proper range. Now, if I reject your deal, or if I give you a punishment that's greater than what you agreed to, then in that case, the law would allow you to start all over again. And none of this, the papers signed or anything you say would be used against them, would be used against you. Is that clear?
Yes, Judge, it's clear.
Right. Now, just to make double sure, all the papers that you signed that are part of this proceeding, you had your attorney help you and review and give you her advice. Is that correct?
That is correct.
All right. Another document briefly is one where I certify as the judge, I certify to you. It's called the Trial Court Certification of Defendant's Right of Appeal. In that document, I certify that you do not have a right of appeal if you persist in a plea bargain. Do you understand that?
Yes, Judge, I do.
Okay, now you've obviously applied for probation because obviously you don't want to go to jail. What kind of probation are we looking at, State?
Your Honor, it's going to be deferred.
All right. So if that's going to be deferred, I need to make one thing. Well, I need to explain some things to you. Deferred adjudication probation is a system wherein you enter into a written, legal, binding agreement between you and this court. And part of that agreement is, first of all, that I am not going to find you guilty. And I know you're going to enter a plea that is sufficient for me to find you guilty. If you live up to 100%, listen again, if you live up to 100% of the conditions of supervision, then the case will be closed and you're not convicted of the charge to which you plead. If you fail or refuse to live up to 100%, the state may ask me to give you official notice, bring you in here for a hearing, at which time the state may offer evidence, and if I think it is appropriate, in my opinion, based on the evidence, then I can give you a final conviction that will follow you the rest of your life, and I'll have the opportunity or the responsibility to consider 100% of the punishment for the offense to which you're pleading. Now, apparently this is going to be a Class B plea, state. Hello, somebody.
Correct, Your Honor. It's a Class B.
All right. On a Class B misdemeanor, if you come back and I have to find you guilty, enter a conviction, you'll be looking at a fine anywhere from $0 all the way to $2,000, and jail anywhere from 0 days all the way to 180 days. Is that clear, ma'am?
Yes, Judge, that's clear.
All right. Now, state, what is the motions of the state?
The state would move to waive the extreme intoxication enhancement and proceed on a DWI first.
Objection, Your Honor.
All right. And to there being no objection, then the court approves the motion, and you are no longer charged with DWI with a blood alcohol content of 0.15 or higher. You're now charged with DWI misdemeanor B, or DWI first, and it's a lower punishment level, okay? The DWI extreme is punishable by a fine from $0 to $4,000 and jail from 0 days to 1 year. So you've already started off well with the assistance of Ms. Blake. So to that charge, ma'am, that is DWI first, how do you plead?
No contest, sir.
A no contest plea is considered a guilty plea in this court. You understand that?
Yes.
And on a no contest plea, I could, just based on that, go ahead and convict you now. You understand that?
Yes, Judge, I do.
Okay. Now, did anyone threaten you, intimidate you, or promise you anything other than the plea bargain itself in exchange for your plea of no contest?
No, sir.
All right. Then I accept your plea of no contest. I find there is sufficient evidence to find you guilty, but I do not. Instead, I am granting you deferred adjudication. State, tell me the length of the deferred.
12 months, Your Honor.
12 months deferred adjudication. The rest of the punishment?
Yes, Your Honor. $400 fine, fully probated, 48 hours community service, DWI education program, victim impact panel, TAP evaluation and recommendations, and ignition interlock for 6 months.
Now, 2 questions, Ms. Royce. Do you have children that you support?
No, Judge, I do not.
All right. Second one is, what is your total income, either monthly or yearly?
My monthly, I do like small odds and ends jobs where I can find. I haven't been able to find sufficient good work because of this. So I'd say it totals up maybe about to 11 to 1,500 a month that I'm able to make.
All right. Have you been on ignition interlock all this time?
I have, sir.
Okay. I accept the agreement. I grant you 12 months deferred adjudication. You're fined $400 If you live up to all of the conditions, 100% of them, then you will not have to pay the $400. If you violate the conditions, then you may wind up paying that and more. Is that understood?
Yes, Judge.
You'll perform 48 hours of community service restitution. You will participate in and complete the DWI education program, the victim impact panel. You will submit to a TAP evaluation and the recommendation subject to my approval. You'll have ignition interlock installed in your vehicle for 6 months. During those 6 months, it'll be 6 months continuous, and you're not to drive any other vehicle without your ignition interlock. The supervisory fee, I will charge you the minimum, which is $25 a month. All right. Any question? By the way, 2 things. You have to come by the courthouse, the offices, and within 7 days, and have your thumbprint placed on the documents that are required by law, the case documents. And secondly, you need to stick around and wait a little while. Maricela Luna, you will meet with her. By the way, the conditions of supervision will be read to you by probation. You will sign those and they'll put a copy in your hands. Is that clear?
Yes, Your Honor.
All right. Any questions, Ms. Ruiz?
I do have one. I spoke to Angela Blake about the plea bargain, and there was a section of it that I wanted to address as far as having the opportunity to possibly expunge my DWI in the future.
Your Honor, we discussed that with Ashley, and we wanted to make a notation on the record that my client was in fact able to expunge the case if she filed it after at the statutory requirements are been met.
Okay.
Your Honor, the state's in agreement with leaving that option open.
All right. Well, then
I think there's
we're
a
all
check
on the
mark.
same page, apparently.
Well, Judge, if you could make a notation on the plea bargain page. There was a check. It was checked, and then which does not allow her to, Ms. Ruiz, to do the expunction.
So in other words, there will be no bar to her applying for consideration.
Right. And so if you don't mind, if you could just mark that out, that X out, or that check mark out.
You don't have
Oh.
that plea bargain page yet, Judge. I don't know why.
It's not in the file.
Okay.
Do you remember signing it, Angela?
Yeah.
Okay, well, we'll just wait till Linda prints it this afternoon.
Okay. I will make a note of that. Let's see, today is the
18.
18th of November, a week from Turkey Day. Mhm. All right. Plea, no contest. Note, no bar to application or expunction. That's noted as part of the plea.
Thank you, Judge.
On the file.
Thank you,
Okay,
Your Honor.
you're welcome. Anything else, Ms. Blake?
That's it for me.
Yoo-hoo.
Hello.
Anything else, Miss Blake?
That's it.
All
Did I
right,
freeze? I
state,
must have froze.